I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
All right, everyone. Today we're looking at one of the most clueless sovereign citizens I've ever come across. Seriously, how are people like this still around in 2025? This guy literally struggles to read, yet he believes he can just stroll in a court and represent himself like some sort of legal genius. His main argument is that he isn't getting a fair trial because he only had 1 hour to study the law, while the prosecutor spent 7 years in law school. You honestly couldn't make this up. It's like showing up to a marathon with no training at all, and then complaining that Olympic runners had more time to prepare. This is going to be painful to watch, but also pretty entertaining. Let me know what you think in the comments as you watch. Let's jump in and see this guy get completely shut down by the law.
Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read.
Good grief, this guy can barely read. And now he wants to stand in court and read his own motions like he's some kind of legal prodigy. Honestly, what reading level would you even give him? I'd probably say around 6th grade. And that's being pretty generous. But the real kicker is that he's actually complaining about not having enough time to study the law. Sir, do you really think the judge is going to pause your case for the next several years so you can go for a law degree? The sense of entitlement is unbelievable. Back in my day, if you didn't know how to do something, you found someone who did. You didn't throw a fit and expect everything to revolve around you. The court has already given him options. Hire a lawyer, accept a public defender, or represent yourself if you actually know what you're doing. Clearly, he doesn't. What's next? He's going to ask for a delay so he can get sworn into the Supreme Court. What do you guys think about this guy so far? Let's jump back in.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court.
Is anyone else just waiting for the judge to basically say, "Nice speech, little guy, motion denied"? Because honestly, that's exactly where this seems to be going. This guy really didn't need to read his motion like he was delivering some historic address. I swear, it almost feels like the judge only let this sovereign citizen continue for the entertainment value. Like, sure, go ahead, let's all get a chuckle out of it. And that's probably the only reason she didn't shut him down right away. Judges absolutely have the authority to deny frivolous motions outright, especially when they waste the court's time. And this is a textbook example. Rule 11 of the Federal Rules of Civil Procedure exists specifically to stop this kind of nonsense. Courts can even sanction people for filing baseless motions just like this. But hey, maybe he thinks if he keeps talking long enough, the judge will suddenly recognize his so-called sovereign wisdom and dismiss the entire case. Spoiler alert, that's not going to happen.
Stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws to that. If we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this guy pretending to be clueless, or is he really this lost? I'm leaning toward him playing dumb, because it's hard to believe someone would be this foolish while facing real jail time. This isn't a high school pop quiz where you can just wing it and hope everything works out. His entire defense falls apart when you remember he could have had a court-appointed attorney for free. But instead of accepting that help, he'd rather waste everyone's time filing pointless motions and then complain that he only had 1 hour to study for court. What did he think this was, an open book test? He reminds me of that one kid in school who clearly didn't prepare for a presentation and instead of admitting it, just starts making things up and hoping nobody notices. Newsflash, everyone notices. Let me know what you think. Is he playing dumb or not? Let's jump back in.
And if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And oh, you didn't want that either. So then we went through the hearings and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a what, 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus information. You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez.
Well said. In my opinion, the judge handled this really well. She probably could have shut him down a bit sooner, but then we wouldn't have gotten such a good laugh at his expense. Seriously, what did this guy think was going to happen when he walked into court? Did he actually believe he was about to talk his way to victory when he could barely read from that crumpled piece of paper he looked like he picked up off the jail floor? This is exactly why understanding your rights matters. Not so you can throw around made-up legal arguments, but so you don't end up like this, embarrassing yourself in front of a judge who has zero patience for games. At the end of the day, courts don't entertain nonsense like this. Even though the judge was fairly calm and gave him a few words at the end, there's no way the court is going to consider emotion when free legal representation is literally available. It just doesn't make sense. This was easily one of the weakest arguments I've ever heard. He's basically a walking example of what not to do in a courtroom. The law isn't some choose-your-own-adventure book where you can invent the rules as you go. That said, he definitely gave us some solid entertainment today. I'm going to wrap it up here. Let me know what you thought about this guy. He's a textbook sovereign citizen, and honestly, I'd probably put his reading level around 6th grade, and that's being generous. Actually, after hearing that, maybe closer to 3rd grade. Either way, it's definitely not very high. If you enjoyed this, I'd really appreciate a like and subscribe. Also, drop your recommendations in the comments for any court hearings you want me to cover. I post every single day, so I can definitely check them out. Thanks so much for watching, everyone. Take care.